Glenn, could we start by talking a little bit about your involvement with the American Bar Association and how you worked your way up to be president of the International Law Section?
Yeah, I've been involved, I've been a member really since I got out of law school. I became actively involved probably around 1997, I would say, when I became active in the International Litigation Committee of the section. And handled a few projects, became a vice chair of the committee, and then became the co-chair of the litigation committee, and gradually just worked my way up through a range of positions. I ran the International Legal Exchange Program for the section for a while, was the programs officer, and then secretary, and then ultimately vice chair. Once you're a vice chair, it's a 3-year progression through chair-elect and then ultimately chair. So I actually become chair of the section this August.
What is the overall purpose of the section? Is there one general theme that or mission that the section has?
Well, the tagline is your gateway to international practice. And the gateway concept, I guess, is something that is important to the section. It basically is, in a sense, a portal for American lawyers to the outside world, and likewise for foreign bar associations and non-U.S. lawyers to the American legal community. So we're actively involved in publications. We have a quarterly law journal, monthly newsletter, a very large library of books, meetings. We have 4 meetings a year, 2 in conjunction with the larger ABA, and then 2 standalone meetings. We're actively engaged in development of policy. We liaise with the State Department, and we're involved in various projects. For example, our International Legal Resource Center, which is a joint venture with the United Nations Development Program, the UNDP. So I covered a lot of ground there, but we call it the 4 Ps, publications, programs, policy, and projects.
What does your travel schedule look like from starting this August through the following August?
Well, it's not mapped out for the entire year, but I can tell you that already I'll be in Sao Paulo, Brazil, in Lima, Peru, Vienna for a joint meeting that we're holding with the International Bar Association. We have a standalone conference that I'll be chairing in Moscow on dispute resolution in September. I'll be attending the International Bar Association meeting in Madrid in October. And then in January, we will be taking what we call an ILEX trip, International Legal Exchange trip, to Australia and New Zealand. And we have a tentative commitment that, actually we have a relatively firm commitment from Justice Scalia, the U.S. Supreme Court, to join us. I'll be in Kiev, Ukraine, probably, I want to say that's in August. But those are just trips through January. Beyond that, it's not mapped out yet.
How do you grapple with the travel and your practice, keeping your practice going at the same time? Is that difficult?
It's a lot of juggling. Fortunately, with the internet and Blackberries, you're able to stay in touch with the office. But it's a lot of juggling.
So you probably couldn't schedule a lengthy trial during that period or anything like
that?
Right. Do you think that international law or international connections are more important to American lawyers today than they were 10 years ago?
They absolutely are. I think there are very few law practices of any sophistication that, at least a business law firm, where your practice doesn't touch on global matters, whether it's the fact that you've got a foreign client who may be an investor in the United States, or just the nature of the legal issues. In litigation, it is just so common now that evidence may be located abroad or one of the parties is from abroad. It really permeates legal practice.
Are you starting to see a stronger legal system in countries like China, where if there is a business dispute, it can be resolved?
Yeah, they have a long way to go, but their court system is certainly improving. And one of the I guess it's not really an innovation anymore, but over the last, since 1958, when the New York Convention on the Enforcement of Foreign Arbitral Awards was issued, adopted by the U.S., as I recall, in 1970. But basically, most disputes are now handled, of any size, are handled by arbitration. And so if you've got a commercial dispute, the two parties will have in their agreement a provision providing for arbitration by the International Chamber of Commerce or the AAA, or the AAA's international arm, the International Center for Dispute Resolution, any number of organizations, and that dispute, that arbitrator or panel of arbitrators will handle the dispute, and then it's enforced by treaty by the courts of the other country. So you avoid a little bit of the home cooking that way.
How much of a hassle is that to go through that process for a company?
It really depends on, in terms of the arbitration itself, a lot depends on how large the dispute is, who's administering it. Some of the institutions that administer those arbitrations are more expensive than others. The ICC has a high reputation for quality, but it can be relatively expensive. The AAA less so. The enforcement process really varies widely by country as to how, it really is dependent on the courts. How good, if you're trying to enforce an arbitration award against a Russian company, for example, in Russia, it's going to be more difficult than it would be, say, here. But even so, there's statistics, in Russia is actually an area that I've done some work, that up to 80% of all our foreign arbitration awards are enforced by the Russian courts. So it's better than you might expect.
Because I think that's the one fear that companies have when thinking about trading abroad is they worry about not being able to get their money or not having any legal rights when they get into a dispute.
Right.
But you say you think that is improving over time?
I think generally it is improving. Of course, it depends on the countries. In some countries, it's deteriorating. But I think there's certainly a trend more to the rule of law, and that's one of the missions of the American Bar Association. For example, we have a number of programs to train judges, both over there and bring them over here, and just sort of spread this notion of the rule of law. The section of international law of the ABA. In the 1990s started something called CELI, which a very extensive training program for judges and other professionals in Eastern Europe and Russia, which has been relatively successful. So, but to get back to your question, I think that it is improving, and there are any number of mechanisms to minimize the risk, whether it's through using international arbitration, where if the other party, the losing party, is not going to voluntarily comply with the award, you have to go to court, but the level of review to enforce the award, the standard is very, very strict, and you're much better off trying to enforce an arbitration award in your favor, for example, than just starting an entirely new legal proceeding in that country. And then there are, various ways of just protecting yourself through contract, whether, you don't ship goods abroad without either prepayment or, letter of credit or various other mechanisms. I think that it's we're entering an important period, with the financial crisis. I think that, international law will play an increasingly important role. You just see how interconnected the world is right now with, a bank failure in Iceland can have major impact in, say, Europe and the rest of the world, for example. Everything we do is just so much more interconnected today, and that is only going to continue.